Alright, the unclassified for official use only domestic investigation operation guide. Domestic Federal Bureau of Investigation, Department of Justice, December 16, 2018, and we're on 34. All right, Chapter 4, your privacy and civil liberties, least intrusive massive civil liberties and privacy. The FBI is responsible to protect the American public not only from the crime of the terrorism, also included within the constitutional right. Accordingly, all of the Attorney General's domestic investigational activities must be carried out in full adherence to the Constitution, federal law, of the privacy and principles of civil liberty and privacy. The FBI have a long-established commitment with protecting the civil liberties of the American, as investigating threats for the national security, public safety. Also discussed below, complying with the FBI within comprehensive infrastructure, legal limitation, oversight, self-regulation, and shall actively ensure for the commitment is on because of our applicability of the achievement of the mission required that we have trust and confidence of the American public. Because of the trust and the confidence can be significantly shaken by our failure to respect the limits of the power. Special care must be taken on all employees to comply with these limitations. Purpose of the investigation activity. Most of the important safeguard of the Attorney General guideline domestic for the one is intended to ensure the FBI employee for the respect of the constitutional right of the American is threshold for the requirement of all the investigation activity to have the authorized purpose. Under the Attorney General guideline, the authorized purpose must be authorized national security, criminal, or foreign intelligence collection purpose of simply stating such a purpose is not sufficient, however, to ensure the compliance within the safeguard critical authorized purpose not to be or appear to be arbitrary with the contrived, that it will be found and well documented that the information sought with the investigative method is used to often obtain the focus, the scope, of the type of the time of the matter to achieve the underlying purpose. Furthermore, the constitutional provisions set limits which the purpose must be and may not be solely with the monitor to extract of the rights that they are protected with the Constitution. Equal important authorized purposes may not be based solely on the races, ethnicity, national origin, or religion. It's important to understand how the authorized purpose of the requirements of the constitutional limitation relate to one another. For example, the individuals or groups that communicate with each other, with members of the public in any form of the pursuit of the social political causes, for the opposing of the war, foreign policy, for the protesting of the government actions, promoting certain religious beliefs fundamental with the constitutional right to do so. No investigative activity may be conducted for the sole purpose of the monitoring of the exercise of these rights. If, however, there exists a well-founded basis for the conduct of investigation activity for the authorized person lifted above the base, if it's not solely for the race, for the ethnicity, the national origin, religion of participants. The FBI employees that may assess the investigate these activities subject to the limitation of the Attorney General guidelines, domestic investigation operation guidelines. The situation investigate activities would not be based solely on the constitutional protected conduct on the race of ethnicity, national religion. Finally, although investigating activity will be authorized in a situation, it is important to be conducted in a manner that does not materially interfere with the ability of individuals to group and engage in the exercise of constitutional protected rights. All right, oversight and self-regulation. Provided the Attorney General guideline domestic with the otherwise Attorney General guideline and oversight of the Department of Justice components designated they ensure the activity of the FBI are lawfully appropriate, ethical as well, but the effective of the protecting the civil liberties and privacy of the individuals and the Department of Justice, the FBI, and inspect the Division Office Inspection and Counsel with the Office General Counsel with along with the FBI employee with the chair with the responsibility to ensure the FBI meets these goals. In the criminal investigation area with the oversight of the FBI activity of the traditional come with the prosecutor with the district court with the main national security investigation does not result with the prosecution. The oversight of the mechanisms are necessary for its feature of the Attorney General guideline, the domestic facility with the Department of Justice, with the National Security Directory Division, oversight function of the national security and foreign intelligence collections are relevant. The requirement of the provision include with required notification of FBI, the Department of Justice, and the National Security Division, concerning full investigation and involved with the foreign intelligence collection, full investigation of the United States person in relation to the threat of the national security investigation involving sensitive and investigative matters, annual report with the FBI, with the Department of Justice, the National Security Defense, from the FBI with the Foreign Intelligence Collection Program that include the information reflecting the scope of the nature of the foreign intelligence collection activity of each for the field FBI field office, except for the Department of Justice, the National Security Division, to inform the obtainment of the FBI with the National Security Foreign Intelligence Activities for the General Authority with the Assistant Attorney General National Security to obtain reports of the FBI concerning these activities. Attorney General Gun Domestic Intro 4C. The Department of Justice, the National Security Division, oversight a section of the FBI Office of General Counsel responsible for conducting the regular review of all aspects of the FBI National Security Foreign Intelligence Activities. Reviews conducted by the FBI Field Office of the FBI Headquarters Division broadly examine each of the such of the activities complying with the Attorney General guidelines domestic with the other applicable requirements. Further explain A further example, the oversight mechanisms include the involvement of both the FBI and the prosecutorial personnel, reviewing undercover operations involving sensitive circumstances of the non-requirements of the investigation involving sensitive investigative matters. Notice the oversight of the provision of the enterprise investigation involved with the broad examination of groups implicated with the criminal national security threats. These requirements proceed help to ensure the rules of law with respect to the FBI activities. The public confidence is maintained in these activities. General Guideline Domestic Intro 4C. In addition to the above mentioned oversight that even the Department of Justice has played for the FBI and subject to the regime of the oversight of the legal limitations, self-regulation, designate to ensure and strict the adherence to civil liberties regime. The comprehensive that has many factors, including the following: Foreign Intelligence Surveillance Act of 1970 as amended to Title III of the Omnibus Streets Act of 1968. These laws establish the process of obtaining with the judicial approval of electronic surveillance physical searches for the purpose of collecting foreign intelligence electronic surveillance for the purpose of collecting evidence of crimes. Through the Whistleblower Protection Act of 1988 and 1998, these laws protect the whistleblower with the Retaliation Freedom of Information Act 1966 to the law to provide the public access for the FBI documents that are not covered by a specific statutory exemption. Privacy Act of 1974, the purpose of the Privacy Act with the balance of the government need for the maintaining information for the United States citizen and legal permanent resident aliens, for rights for the individuals to protect against the unwarranted invasion of the privacy with the stemming of the government collection, use, maintenance, dissemination of the information of the Privacy Act that forbids the FBI with the other federal agency for the collecting information about how individuals exercise the First Amendment rights and life of the collection expressly authorized by statute. Individual protecting within the scope of the authorized law of the enforcement activities. Title 5 U.S. Standard Code 552A E7. They accept the collection of foreign intelligence activities authorized by the Attorney General Guideline. The domestics are authorized law enforcement activities and activities where they otherwise statutory authorities for purpose of the Privacy Act. Foreign intelligence collections authorized law. Foreign intelligence collection is not an authorized law enforcement activity. Alright, congressional oversight of the executive of the various committees of the United States, of the Congress, primarily with the Judiciary, Intelligence Committee, with each committee, with the exercise of the regular, vigorous oversight of all aspects of the FBI operations, and with the National Security Act of 1947, required the FBI to keep the intelligence committees for Senate, House, Representative, fully with the currently with informed of the substantial intelligence of the activity, oversight of the significantly increase of the breadth and sensitivity since for the 1970s provides important additional assurance for the FBI conduct for the investigation according to the law and the Constitution. The FBI counterintelligence, counterterrorism operation are subject to the significant self-regulation, oversight of the end with the conduct with the Congress, the insight, intelligent oversight with the board, with the compromise with the members of the President's Intelligence and Advisory Board. Also conduct the oversight of the FBI, with among the other responsibility and the Intelligence Oversight Board reviews violation of the Constitution and national security, executive order, presidential decision, directive of the FBI, any other intelligence agency with the issue reports thereon with the presidential attorney general. In terms of the FBI, with the safeguards include the Office of the General Counsel, privacy, civil liberties units with the review plans, any record system proposed with the FBI compliance with the Privacy Act related with the privacy protection requirements of policy for the criminal, national security, undercover operation review committee with the compromise with the senior Department of Justice of the FBI with the officials will review all proposed undercover operations that involve the sensitivity circumstances, the sensitive the operation review committee compromised of that's been expedited of the all FBI has the obligation to report violation of domestic investigation operation guide their supervisor or other management official appropriate authority for the FBI with the requirement of the training the new FBI employees periodic training of all FBI's employees to remain currently with the latest guidelines change with the law with the regulations judicial decision related with the constitutional rights and liberties. Alright, Attorney General guideline with the domestic investigation operation guide set forth standard with the requirements under which the investigative activity may be initiated designed to provide the API employees with a framework with the maintain with the proper balance with the between the public need with the effective law enforcement protection for the national security protection of civil liberties and privacy. Among the provisions specifically serve to protect the civil liberties and privacy are the following: prohibition against initiating an investigation based solely on the exercise of the First Amendment rights and other constitutionally protected activity, the requirement of the API employee with the least intrusive method reasonably under circumstances achieving the investigative goals. There are prohibition against engaging in ethnic and racial profiling, further in context collection foreign intelligence. The FBI has further required to operate only openly, consensually with the United States person to extent the practical. All right, protecting the First Amendment right. With the fundamental principle of the Attorney General guideline of the FBI investigation operations under the first guideline was issued in 1976, but has been investigated activity been not solely on the exercise of the rights of the guarantee of the First Amendment of the United States Constitution. Principle carried out of the present day with the Attorney General guideline of the domestic if corollary is the principle of the Privacy Act of 1974 with the Title 5 U.S. Code 552A with the prohibits the retention of the information describing how a person exercises rights under the other First Amendment unless a valid law enforcement purpose is there's valid law enforcement purpose. First Amendment states that the Congressional shall not make no law respecting establishment of the religion, prohibiting free exercise thereof, the bridging of the free speech of the press, of the right of the people to peacefully assemble in the petition of the government with the redress of the grievances. Although the amendment appears literally to apply only to the Congress, the Supreme Court made it clear along to apply with the activities of the branch, including law enforcement agents of the airport. The FBI purpose of it will be helpful to relieve the introduction of the First Amendment. The FBI shall take no action respecting. In addition, with the word abridging, must understand the bridging as used here will mean diminishing. Thus, is not unnecessary for law enforcement action to destroy or totally undermine the exercise of the First Amendment. The rights of the unconstitutional singularly diminish for the lessening of the ability of the individual to exercise these rights without authorized or investigating purposes is sufficient. This is not to say that it diminishes the First Amendment, the rights of the unconstitutional. The Supreme Court never held the exercise of these rights. Absolutely, in fact, the court sets forth realistic interpretation level of the kind of the government actually violates the First Amendment right. For example, to take an extreme, one could argue that there mere possibility of the FBI agent being present to open forum on the line of the president or online presence would be diminished for the right of speech. For example, the anti-war protester because he or she would be afraid to speak freely with the Supreme Court. However, has never found an abridgment of the First Amendment right based on the subjective fear. Rather, it requires an action that, from an objective perspective, the throne will truly diminish for the speaker's message of his or her ability to deliver it. Pulling plug on the sound system, for example, another requiring protesters to understand a certain requiring protesters to a certain parade route may diminish the particular sense of the delivery of the message. Court has made it clear, however, the legitimate reasons of the public safety, the government may impose reasonable limitation times and place and manner of the exercise such rights, along with the ability to deliver the message remains. Alright, while the language of the First Amendment prohibits the action with a bridge for the enumerated right for the implementation of the prohibition of the Attorney General guideline, the domestic reflex of the Supreme Court decision, constitutional law enforcement action with the impact of the exercise First Amendment rights as stated above, the Attorney General guideline prohibits the investigating authority of the sole purpose of monitoring exercise of the First Amendment rights. The important of the distinction of the language, actual text of the First Amendment language of the twofold line drawn by the Attorney General guideline domestic prohibit them even monitoring exercises of the First Amendment rights far short of abridging those rights. Far short of abridging these rights, and solely for the purpose of the FBI activity, even the requirement of the authorized purpose of all investigative activity provide additional protection exercise constitutional protected rights. The Attorney General guideline the domestic classifies investigated activities involved with religious, political organization, individual prominent within such organization, members of the news, media, sensitive investigative matter of the designation, regarding coverage of the sensitive of the conduct with the traditionally involved with the exercise of the First Amendment right of the groups who associate particularly with the religious purpose and the press, the requirements of the opening of the and pursuing sensitive investigative matter are set forth in Section 10 of the policy of the document. Should be clear, however, the decision below just how persuasive the exercise of the First Amendment, the rights of the American life, and not all protected with the First Amendment activity will fall under the definition of sensitive investigative matter. Therefore, it's essential for the FBI with employee with the recognize the investigative activity may have the impact on the exercises of these fundamental rights, and then be especially sure that such active investigative activity has a valid law enforcement national security purpose, even if it is not sensitive investigative matter, as defined in the Attorney General Guideline, the Domestic Investigation Operation Guide. Finally, it is important to note that the United States person and organization compromised with the United States person do not forfeit the First Amendment rights implicitly because they also engage in the criminal activity to conduct the threat of the national security. For example, an organization suspected of engaging acts of domestic terrorism may also pursue legitimate political goals, may also engage in lawful means of the achievement of these goals, for the pursuit of these goals, for the Constitution and protective of the conduct. Does not insulate them from legitimate investigating focus for the unlawful activities of their goals or in the pursuit of the goals or lawful remains of the protective of the unconstitutional infringement. When an allegation of the First Amendment violation be brought with the court, lawfully is usually to form a civil suit with a plaintiff that has proved some actual or potential harm of the Presbyterian Church by the Virus of the United States in 87 FD 2 D5A18 9 Circular 1989. In a criminal trial, the defendant may seek either both or two remedies as part of the claim to that first his or her First Amendment rights were violated, suppression of evidence of the gathering of the alleged First Amendment violation, claiming typically analyzed for the reasonable cause of Fourth Amendment dismissal of the indication of the base for the outrageous government conduct in violation of due process clause of the Fifth Amendment. Alright, the scope of each of the primary First Amendment, the right for the impact of the FBI investigative activity discussed below with the First Amendment, the established cause, prohibition against the government establishing, sponsoring specific religion has little application of the FBI, but therefore has not discussed here. Free speech. The exercise of the free speech include for the far more simplicity speaking with a controversial topic for the town square, include for the activity of the carrying placards in the parade, sending letters to the newspaper editor, posting a website on the internet, wearing a t-shirt, with a political message, placing a bumper sticker critical on the president of the one over the car with publishing books or articles. The common thread in these examples is conveying a public of the message within the idea of through the words or deeds. Law enforcement activity, they diminish a person's ability to communicate any of these ways may interfere with his or her freedom of speech, thus may not be undertaken by the FBI solely for that purpose. Line between the constantly protected of the speech of the adversary of the violence or for the other conduct may lead to the violence or other lawful, unlawful act must be understood. Brandenburg versus Ohio 395 U.S. 1969. Supreme Court established two-part test to determine whether the such speech are constitutionally protected by the government may not prohibit a device advocacy of the force of violence except with such advocacy the intent with the incite with the imminent lawless action. The two is likely to do so, for Therefore, even a hated rhetoric, often offensive provocation that could be conceivably led to violent response in the future, usually protected. Some of the example of the political activity group that advocate for the website would have taken unspecified action against the person it needs in its view as enemies, whether therefore such suffer property damage and personal injury. Under the Brandenburg two-part test of these missing specifically evidence for the message and provide constitutional protection for the reason the law enforcement may take no action in effect to block the message or punish the sponsors. Despite the high standard of the prohibiting free speech of the punishing to engage in, the law does not preclude the FBI employee with observing and collecting any of the forms of the protected speech with considering it in content as long as these activities are done valid law enforcement national security purpose of conducting in a manner that does not unduly infringe upon the ability of the speaker to deliver his or her message to be an authorized purpose. So there must be one authorized by the Attorney General guideline domestic. Further, the FBI assessment predicted investigation other authorized function as providing the assistance to other agency. Furthermore, following the standards of initiating the proving the assessment predicted investigation is named the domestic investigation operation guide. The FBI will ensure that the rational relationship between the authorized purpose of the protected speech of the reasonable person with the knowledge of the circumstances could understand information is being collected. Returning to the example that posed with above, the group of advocacy of the action could be directly related to circumstance of the property of the damage suffered by one's group known as the targets collecting the speech, although lawfully protected car and lawfully occur with similarly listening to the public talk by a religious leader who is suspected of raising funds for a terrorist organization may yield clues as to his motivation, plans of action, and hidden message into his followers. The FBI should not therefore avoid collecting First Amendment protection speech if it is relevant and not authorized the Attorney General guidelines domestic purposes. As long as they do, then the manner does not inhibit delivery of the message ability of the audience to hear, as long as the method of collection least intrusive means feasible to gather relevant information. In summary, during the course of lawful investigation activity, the FBI may lawfully collect, retain, consider content and constitutionally protected speech so long as the collection is logically related to the authorized investigative purpose. The collection does not actually infringe on the ability of the speaker to deliver his or her message, and through the method of collection, the less intrusive alternative feasible. Alright, B. The exercise of religion. Like all the First Amendment of the freedom of the free exercise of the religion club of the broad of the commonly believed of the first of the any form of the worship of the deity, even form of the commonly understood of the to be called with the fringe sects, as well as the right not to worship any of the deity, but the second protective of the religious exercise also extend with the direct the food that is required by religious etiquette, attendance of the facility, even the regular practice, no matter how unlikely it appears to be intended for that purpose, observance of the Sabbath, raise money, for evangelical or missionary purposes, proselytizing, I've never heard of that. Even controlled environments like prisons, religious exercise must be permitted, subject to the reasonable restriction as into the time and the place and there, and the feature of the First Amendment, the right with the manner of the heightened sensitivity of some of the Americans, especially devote the followers, for then this reason the matter is more likely to provoke an adverse reaction, and if the right is violated, regardless of the religion is involved, therefore an essential investigative activity may impact with the right, but it must be conducted with a manner that avoids the actual and the appearance of the interference of the regular religious practice to the maximum extent possible. While there must be an authorized purpose of the investigative activity that could have the impact of the religious practice, it does not mean that the religious practitioner of the religious facilities are completely free from being examined as part of the assessment of the predicted investigation. So if the practitioners are involved with such of the facilities or youth activities that are projects subject to the FBI authorized investigative and intelligence collection activity, the religious affiliation does not immunize that any of the degree of these efforts over the paramount. However, the authorized purpose of such of the efforts of the be promptly documented, but they also import that the investigative activity directed with the religious leaders and their conduct concurring with the religious facility be focused in the time of the manner so that they don't infringe on the legitimate religious practice of any individual, especially by those who appear unconnected to the activities under investigation. Furthermore, the FBI employees may take appropriate cognizance of the role religion may play with the membership of the motivation, criminal and terrorism, and in private. For example, the affiliation with certain religious institutions, religious sect that is known with the requirement of the inclusion violation organization that is subject to any of the investigation that within the person of the interest of the member of the institution is sect with a rational, permissible consideration. Similarly, if the investigation experience with the reliability intelligence review of the members of the terrorist of the criminal organization are known to commonly pose as the exhibit of the combination religion based on the characters, practices, group leaders, state of the acts of the terrorism are being in religious doctrine, it is rational and lawful to consider such a combination of the gathering intelligence about the group, and even if any one of these itself would constitute the impermissible for the consideration by contrast solely because of the prior of the investigation, particularly with the group that were members of a certain religion that claimed a religious motivation with their acts from the crime and the terrorism, and other members of mere affiliation with the religion itself, and not basically a set of the investigation absent of the known with the direction of the connection with the threat under assessment. Investigation, finally, the absence of the particular religious affiliation could be used in the analysis investigated to eliminate certain individuals from further investigating concerns in their scenario where religious affiliation is relevant. Alright, freedom of the press. Contrary to what you may believe of this first known amendment right is now not owned by the news media. It is relevant with the right of the American people. The drafter of the Constitution believe that the free press was essential for the preserving of the democracy, although the news media typically seeks to enforce the right of the freedom of the press should not be viewed as a contest between law enforcement and national security on one hand, but the interest of the news media on the other. Freedom of the press would include for the such a matter of the responsible and accept of the news making events, the making of the documentaries, posting of the blog, of the news gathering functions, have to accept aspect of the freedom of the press most likely to intersect with law enforcement and national security investigating activities with the category within the news media, the protecting the confidential source of the interest of the agency of the FBI with the gaining access to these sources who have evidence of the crime and national security intelligence often cast seminal case in the deriving of Brasburg and Hayes 408, United States 665, 1977, where the Supreme Court held the freedom of the press does not entitle the news reporter to refuse divulge identity of his source of the federal grand jury. The court reasoned that as long as the purpose of law enforcement is not harassment, vindictive against the press, any harm of the news gathering function of the press of the revealing source of identity is outweighed by need of grand jury to gather evidence of the crime, particularly in response, President Attorney General has issued regulation for the government issuing the subpoena for the reporter's testimony, telephone, toll records, the arrest of the report over the crime related to the news gathering and interview with the reporter, a suspect with the crime arising in the news gathering process. In addition, investigation of the member of the news media with the official capacity of the reporter with the source of the posing as a member of the news media, also sensitive as circumstance of the Attorney General guideline, domestic, other applicable Attorney General guidelines. These regulations are not intended to isolate reporters of the news media with the FBI with assessment, predictive investigation, intended to ensure the investigate activities to seek information from otherwise involved with a member of the news media as appropriate, authorized, necessary for the important law enforcement national security objective, is intrusive means to obtain the information, achieve the goals, and does not unduly infringe upon the news gathering aspect of the constitutional right of freedom of the press. Alright, your freedom of peaceful assembly and petition and government redress. We'll take a pee break. Alright, unclassified. Let's see if this is another tape. I don't know if I'm continuing. Alright, we're continuing the tape. Unclassified for official use only, domestic investigation operation guide. Freedom of peaceful assembly and petition with the government over the redress grievances. Freedom of peaceful assembly, often called the right of freedom of association, present with a unique issue with the law enforcement agent, including the FBI, individuals who gather with others to protest guns. Government actions rally to demonstrate with the favor of the opposition, and the opposition social causes sometimes present a threat of the public safety, either by in the numbers or by the actions anticipated response for the message by creating opportunity for individuals or other groups with unlawful to infiltrate with the compromise of the legitimacy of the group of their own ends. Of the right of the peaceful assembly includes more of the public's demonstration includes as well as the posting of the group's website on the internet, recruiting of the other causes, marketing a message, fundraising, and all protected for the First Amendment activities they have conducted in support of the organization or political or religious and social cases. The right of petition with the government with the draft of the grievance with the link to peaceful assembly of the association include with the decision distinct between the two is an individual may exercise the right of the petition government himself, whereas assembly necessary involves others. The right of the petition with the government includes writing a letter of the Congress carrying out a placard outside of the facility hall that delivers a political message, recruiting others, one of the cause lobbying with the Congress active executive agency with a particular result. For the FBI with the covert presence of the action with the association, also called undisclosed participation with the greatest potential for the impact of the constitutional right. The Supreme Court addressed the issue with the result of the civil litigation arising from one May protests against the Vietnam War, or Laird versus Tatum in 408 U.S. 1, 1972. The court found that mere existence of the investigation of the program consistent of covert physical surveillance into the public area of the infiltration of public assembly, government operatives and source of the other collection of the news article with the other political or publicly available information for the purpose of the determination existing scope of the domestic threat and national security does not by itself violate the First Amendment right for the purpose of members of the assembly, the subject of the chill to the right to assembly based on the suspected presence of the government operatives did not by itself give rise to legal standing, argued that the constitutional right had been abridged. Instead, the court required a showing of the complaint of the government acting would reasonably deter the exercise of that right. Since Laird versus Tatum was decided, the lower courts have examined the government activity over the many occasions with determined whether to give the right of the subjective chill, objective deterrent, with the basic standing requirement that established Laird remains unchanged today. Low courts, however, they have often imposed a very low threshold of objective harm to survive the dismissal of the case. For the example of the plaintiff, it's a very low threshold of objective harm to survive the dismissal of the case. For example, the plaintiffs have shown a low membership in an organizational, low financial support, low reputation status in the community, and low employment of the members have granted standing of this suit. Most significant of the FBI with the standing issue has been low court's evaluation investigating activity of the First Amendment of the Protected Association since law. The courts have been held following and investigating activity constitutional permissible under the First Amendment analysis, undercover participation in group activity, physical and video surveillance in public area of the properly authorized electronic surveillance recruitment operating source for the collection of information from the government, public, and private sources with consent, the dissemination of the information with a valid law enforcement purpose. However, these decisions were not reached with the abstract within every case in which the court has found government action to be proper, the government proved that it was conducting for the unauthorized law enforcement national security purpose, that it was conducted with substantial compliance with the controlling regulation. In addition, when approving these to the technique, the court has considered whether less intrusive techniques were available to the agency. The court have balanced the degree of intrusion of the impact against the importance of law enforcement national security objective. By contrast, since large, the courts have found these technically to be legible objection in initiating investigations solely on the basis of the group of the social political agenda, even if the agenda may be suspected of subversive and infiltrative, sabotaging, neutralizing groups' legitimate social and political agenda, disparaging the group's reputation or standing leading the group of the criminal activity, other probable would be not have occurred, undermining legitimate recruiting of the funding efforts in every such case. The court found government purpose either was not persuasive, was to promote, was too speculative to justify intrusion, potential harm to the exercise of First Amendment rights. Okay, once again, the message is clear of the investigative activity involved assembly with the Association of the United States. Person exercising First Amendment rights must have authorized purpose under the Attorney General guideline of domestic warning will issue the information sought with the technique to employ with rational, related, less intrusive techniques that should always be explored first, and those exercising such activities, which is discussed above, will always constitute the sensitive investigation matter. Should ensure the investigative activity is focused nearly as feasible with the purpose of thoroughly documented. Alright, 4.3 is equal protection under law. Introduction. Equal protection clause of the United States Constitution provides in part that no state that shall make and enforce the law within which they deny any person within jurisdiction of the equal protection of the law. Supreme Court of the lower courts have made and clear where they apply with official act of the United States government law enforcement agents. Specifically, the government employees are prohibited engaging individuals discriminating against the individual basis of races, ethnicity, national origin, religious affiliation. That principles and reflected and implemented in federal law enforcement and the United States Department of Justice guidance regarding the use of race of federal law enforcement agencies, therefore herein after the Department of Justice guidelines. These Department of Justice guidelines state that the investigative, intelligent, collective activities must not be based solely on the race, ethnicity, national origin, religious affiliation, and such activities based solely with the consideration of individuals' definition thereof. Unconstitutional, the same apply with the all investigative of the collection activity, include with the collecting and retaining information, opening, gave the disseminating information, indicating, prosecuting, defendant for the particular applicable, the pretension of dissemination, personally identified with the information about an individual as further illustrated in these examples enumerated below. The constitutional prohibition against individuals discriminated based on ethnicity, national origin, religion is relevant to both national security criminal investigation programs of the FBI. National security investigation often has the ethnic aspect of the members of the foreign terrorist organization, primarily exclusively for the particular country and area of the world. Similarly, ethnic heritage is frequently a common thread running in violent gangs and other criminal organizations. Should be noted that neither new or isolated phenomena, ethnic commonality among criminal and terrorist groups have been relatively constant, widespread across many ethnicities through the history of the FBI. Alright, your policy principles. To assessment of the investigative activity strategy, consider the racial, ethnic, national origin, religious factors properly, effectively to help assure the American public the FBI does not engage in individuous discrimination as found with the policy principles are established. The prohibition against the investigative activity based solely on the race of the ethnicity is not avoided with the concern of the combination of the other prohibited factors. For example, a person of a certain race engaging in a long public speech about his religious convictions is not proper or subject to the investigating activity based solely on any one of these factors, or by combination of all three. Before collecting and using this information, well-founded authorized investigative purpose must exist as with any and all the otherwise prohibited factors are relevant. When race and ethnic relevant factor is to consider should not be the dominant or primary factor. Adherence to the chain will not ensure that it is never the sole factor. To also preclude undue unsound reliance on race ethnic investigating analysis of the reflect with the recognition that there are thousands, and in some cases millions, of the law-abiding people in the American society of the same race ethnicity as to who subject to the FBI investigative activities. It guards activities against risk of sweeping some of them into the next suspicion without a sound investigating basis. The FBI will not collect the use of the behavior, the characteristic common of a particular with a racial, ethnic community investigating factors unless for the bare clear and specific relevance of the matter under assessment and investigation. Policy is intended to prevent the potential collecting ethnic characteristic behavior. It will inadvertently lead to individual identification based solely on such matters, as well as to avoid appearance the FBI is engaged in ethnic or racial profiling. Alright, guidance to the use of the race, ethnic identity assessment predicated investigation. Consider the relation for the common ethnic with the race among the criminal and terrorist of the group. Some of the question prohibition against racial and ethnic profiling is to be effectively applied and not violated. The FBI assessment predicted investigation question arises general to two context. With respect to the individual or group of the individual with respect to the ethnic and racial communities as well. Individual, racial, ethnic as a fact, the Department of Justice guideline permits for the consideration of ethnic or racial identification information, special reporting, such as from eyewitnesses, the general rule race of the ethnic or identified feature of the suspected perpetrator subject, and in some cases a victim is relevant if the basis of the reliable evidence for the information not conjectured or stereotyped assumptions. In addition, the Department of Justice permits consideration of race, ethnic, and other investigating collection scenarios if it is relevant. These examples illustrate race or ethnic with the suspected members of the associated supporters of an ethnic-based gang with a criminal enterprise that may be collected and retained with gathering information about the investigation authorities. Ethnic may be considered with evaluating whether a subject there is or not with a possible associated with a criminal terrorist group, where it is not known to be compromised with the members of the same ethnic group, as long as the dominated factor of the focusing on the particular person is axiomatic that there are many members of the same ethnic group who are not members of the group. For this reason, there may be other information beyond the race ethnic links of the individual or to the terrorism criminal group of the other members of the group. Otherwise, racial ethnic identity would be sole criterion, and that is impermissible. Community, race, and ethnic as a factor. Collection, analysis, demographic. The Department of Justice guideline, FBI policy permit the FBI identification, location, concentrated ethnic communities of the field. Offer domains in these locations responsibility aid with the analysis of potential threat, vulnerables, and overall this domain awareness for the purpose of public informing intelligent analysis. If therefore, example, the intelligent report reveals members of a certain terrorist organization live and operate primarily within a certain concentrated community with the same ethnic location of the community is clearly available, properly collectible data similar to the location of ethnic operated business. Other facilities may be collected if their locations will reasonably contribute to the awareness, threats, and vulnerability, intelligent collection opportunities. Also, members of some communities may be potential victims of civil rights crimes. For the reason some communicating community location may aid enforcement of civil rights information. Such communities should not be collected unless communities are sufficiently concentrated, established as to provide reasonable potential intelligent collection. World would support FBI mission programs, would identify terrorist subjects for certain countries, may relocate to blend and avoid detection. General ethnic racial behavior. The authority to collect an ethnic community with local information does not extend to the collection of the cultural behavioral information of the ethnic community that bears no rational relationship to the valid investigative and analytical need. Every ethnic community with a nation has been associated with a criminal national security threat of the dominant nature of the law. By some of the resident aliens, visitor of the may be subject to the common ethnic behavior, but who is not in conjunction with a crime and a terrorism as subject of the victims. For this reason, the broad brush of collection of the racial ethnic characteristics of behavior is not helpful to achieve any authorized FBI purpose, may create with the appearance of the improper racial ethnic profiling. Alright, your specific relevant ethnic behavior. On the other hand, knowing the behavior and lifestyle of the characteristics of the known individuals who are criminals who impose the threat of the national security biologically, aid within detection, prevention of the crime, the threats of the national security of the community, and beyond focused behavior of the characteristics reasonable believed to be associated with a particular criminal and terrorist element with the ethnic community, not within the community as a whole, may be collectively retained, for example, if known through intelligent analysis of the otherwise individuals associated with the ethnic-based terrorist criminal group and conducted with their finances by certain methods, travel in certain manner, work in certain jobs, come from certain part of their home country, has established links to terrorism. Those are relevant factors to consider with investigating the group, assessing whether it may be present within the community, recognizing the fit between specific behavioral characteristics of the terrorist criminal group is unlikely to be perfect. Therefore, that is, there will be members of the group who do not exhibit the personal behavioral criteria as well as the persons exhibiting the behaviors who are not members of the group. They were nevertheless in order to maximize IPI mission relevance to minimize appearance of the racial ethnic profiling criteria used to identify members of the group of the larger ethnic community which belong to the focus as in so narrowing intelligent reporting other circumstances for the permit of the intelligent reporting insufficient act so that reasonable to believe that the criteria will include an unreasonable number of the people who are not involved, then it will be inappropriate to use behavior standing alone as the base of the FBI activity. Exploited ethnic behavior related category information can be collected with the behavioral cultural information of the ethnic and racial communities such as the reasonable like to be exploited by a criminal or terrorist group who had hid within those communities in order to engage in illicit activities undetected. For example, the existence of the cultural tradition of collecting funds from members within the community to fund the charitable cause of the homeland at a certain time of the year and how that it was accomplished would be relevant to the intelligent report revealed unto the many donors and charitable cause of the Beware Front of the terrorist organization over the support of the community intent with exploiting the unwitting donors for their own purposes. Alright, your least intrusive method overview. The Attorney General guideline domestic for the requirement of the least intrusive means of the method concerned within the operable operational sound and effect that youth is obtained and intelligence and evidence in lieu of the more intrusive method. The principle is also reflected in Executive Order 123333, which govern the activity of the United States Intelligence Committee with the concept of the least intrusive method that apply with the collection of all intelligent evidence regarding the collection of foreign intelligence that is not collected as part of the FBI traditional national security criminal mission. The Attorney General guideline provides that open and overt collection activities must be used in the United States person if feasible. By emphasizing use of the least intrusive means for the obtaining intelligence evidence, the FBI employees can effectively and execute the duties with mitigating potential negative impact of the privacy and civil liberties of all the people encompassed for the investigation, including targets, witnesses, victims. These principles is not intended to discourage the FBI employees from seeking the relevant necessary intelligence information for the evidence, but rather is intended to encourage investigators to choose the less intrusive and still effective means of the available options to obtain the material. Principles embodied with the statute of the Department of Justice and policy variety of the topics include electrical surveillance, use of tracking devices, temporary detection of suspects, forfeiture, and in addition with the concept of the least intrusive method that can be found in the case as a factor considered in assessing a responsibleness and investigative method in the face of the amendment that due to the purpose of the violation and claim Clark Library of the Congress in alliance to the End Repression versus City of Chicago and Elrod versus Burns. The general approach to the least intrusive method, the concept applying with the concept of the less of an intrusive method, investigating intelligence collection scenarios is both the logical and process of the exercise of the judgment. It is the logical instead of the FBI employee must first determine the relative intrusiveness of the method that would provide information relevant to the assessment predicted investigation within the time frame required for the assessment predicted investigation, consisting of the operational security and the protection with a sense of the sort of the methods in a manner that provides confidence in the accuracy of the information. Determine the least intrusive method that also requires sound judgment because it is clear that the factors discussed above are not fixed points on the checklist. They require careful consideration based on thorough understanding of investigating objects and circumstances. Alright, determining intrusiveness. Determining intrusiveness in the primary factor should be the degree of the procedural protection established by law with the Attorney General guideline of domestic provided the use of the method, use of the factor of the search warrant, wiretap, the uncovered operations is very intrusive. By contrast, investigation methods with limited procedural requirements, such as checks of the government with a commercial database for the communication with established sources, are less intrusive. Following guidelines designed to assist the FBI personnel with judging relative to the intrusiveness of the different methods. Nature of information sought. The investigative objective generally dictate the type of the information required from whom it should be collected. Subpart is not intended to address the situation where the type of the information needed, its location is clear for the consideration. Alternatives would be pointless. When the option exists, however, to seek the information at any of the variety of places less intrusive, to seek the information less sensitive, less protected places. Similarly, obtaining information for the protected statutory scheme, financial records, or evidentiary privilege during your client communication is more intrusive. The obtained information is not so protected position there as exists a reasonable expectation principle of privacy with the Fourth Amendment of the private communications. Obtaining the information is more intrusive than obtaining information that is normally exposed to the public view, as to which the unreasonable expectation of privacy. Scope of the information sought. Collect the information regarding the isolated events, such as a certain phone number called on a specific date and single financial transaction, at least intrusive and invasive of an individual's privacy, than collecting a complete communication or a financial profile. Similarly, a completely credit history is a more intrusive view of the individual's life than a few isolated credit charges. In some cases, complete financial and credit profile is exactly what the investigation requires. For example, the investigation of the terrorism, financing, money laundering. If so, the FBI did not hesitate with the appropriate legal process to obtain such information, particular requirements are satisfied. I also recognize the operational security, such as the source of protection, may dictate seeking the wider scope of the information for the absolute necessary for the purpose of protecting the scope of specific target and source. When doing so, however, the concept of the least intrusive alternative still applies. The FBI may obtain more data with the strictly needed, but it should obtain no more data than is needed to accomplish the operational security group goal. Scope of the use of the method. Using the method manner with the capture of the greater picture of the individual group of the activity is more intrusive than using the same method, a different one that is focused in with the time and the location to a specific object. For example, it is less intrusive the tracking device to vary point-to-point travel with the use of the same device with the tracking individuals' movements over the sustained period of time as sustained tracking on the public highways, and would be just as lawful, more intrusive because they capture the greater portion of the individual's daily movements. Similarly, surveillance may be closed-circuit television that checks a discrete location with a discrete time frame and less intrusive than 24/7 coverage of a wide area. For another example, a computer intrusion device that captures only the host computer navigation information far less intrusive than one that captures file content. Alright, source information sought. It is less intrusive to obtain information from the existing government source of the state, local, tribal, international, and federal partner of the public available to have with a commercial database that obtain with the same information from the third party, usually through a legal process that has confidential relationship with the subject of the financial academic institution. Similarly, with obtaining information from a reliable confidential source who is lawful in possession of the information lawfully intended to disclose, such obtaining an address for the employee with a local employee utility company, less intrusive than obtaining the information for any confidential relationship with the subject with the recognized with the category with the accuracy, procedure, reliability of the information sought is an important factor such as using a source of information. For example, the information that is available, the confidential source of the grand jury subpoena, the national security level, the ex parte order, the other process that may be required in order to ensure informational integrity. The risk of the public exposure, seeking the information above the individual group of the under circumstance of the creative risk of the contact with itself, the information itself will be exposed. Will be exposed to the individual's group of determined embarrassment. Particularly if the method used carries no legal obligation to maintain silence. It is more intrusive than information gathering does not carry that risk. Interviews the employer's neighbors and associates, for example, the issuance of the grand jury subpoena at the time of the investigation has not yet been publicly exposed. Area more intrusive than methods gathering information covertly. Similar interviews of the subject of the discrete location would be less intrusive than an interview at For example, a place of employment at other locations within where subject is known. There is a limited utility of the list of the intrusiveness factors. Certain factors may be inapplicable to the given investigation. In many cases, the choice and scope of method will be dictated wholly with the investigation object. For the circumstance of the foregoing is not intended to provide comprehensive checklist and over with the continuum of intrusiveness, intended instead to identify the factors involved with the determination of truthiness and tune FBI employee to select within each applicable category a least intrusive method of operational circumstance of the permit. In the end, selecting the least intrusive method of accomplishing objective is a matter of the sound judgment, excessive sound judgment. However, the consideration of these factors should be ensured that the decision to proceed is well funded. Standard balancing intrusion and investigation requirements. Once an appropriate method is deploying with the determined with the reviewing the appropriate authority, should be balanced the level of intrusion against the investigative requirements. The balance test is particularly important with the information sought and involved with a clearly established constitutional statutory evidentiary rights and sensitive the circumstances, such as obtaining information for the religious, academic, institution, public fora, where the First Amendment rights were being exercised. We should be applied in all circumstances to ensure that the least intrusive alternatives feasible is being utilized. Balancing the factors above the consideration discussed below will help determine the method of the extent of the intrudes and privacy of the threat and civil liberties proportionate with the significant in the case of the information sought. Consideration on the investigation side of the balancing scale includes seriousness of the crime, national security threat, strength and significant intelligence of the information to be gained, amount of the information already known about the subject group under investigation, requirements of operational security, including protection of the source of the method. If, for example, the threat is more remote, the individual involvement is speculative, the probability of the obtaining of the probative information is low, the intrusive methods may not be justified, they may do more harm than good, and any other end of the scale, if the threat is significant, possible, imminent, e.g. a bomb threat, aggressive measures would be appropriate regardless of the intrusiveness. In addition, with respect to the investigation group, the terrorist and criminal nature of the group, the membership is well established, Al-Qaeda, Ku Klux Klan, Colombo, Family, Alaska, and Cosa Nostra. There is less concern with the First Amendment activities in stake than there would be a group whose true character is not yet known. The Islamic charities suspected of the terrorist funding, many of those who members are solely exercising First Amendment rights. Anti-war protesters suspected of being infiltrated with violent anarchists. This is not such as the investigators should be less aggressive in determining the true nature of the unknown group, which may be engaged in terrorism, other violent crime. Indeed, more aggressive and timely approach may be in order to determine whether the group is violent to eliminate its threat. Nevertheless, the First Amendment right are at stake choice and use of the investigative methods. Should be focused in a manner minimizing potential infringement of those rights. Finally, the investigation progresses. The subject of the group's involvement becomes clearly more intrusive method that may be justified. Conversely, if reliable information emerges refuting an individual's involvement in the group with criminal and terrorism connections, use of investigative methods must be clearly evaluated. Another consideration to be bound with the operational security is likely to less intrusive the feasible method the selected subject would be tackled, used, and after his activities include his meanings of the communication, the thwart the success of the operational security, particularly with the national security investigation, should not be undervalued, may be in self-justified covert tactics in which other circumstances would not be least intrusive. Conclusion: the foregoing guidance is offered with as if the FBI employs to navigate the often unclear course of select with the less intrusive investigative method that they effectively accomplish for the objective of the goal at hand. The final analysis of the choice of the method of balancing impact of the privacy and the civil liberties with operational needs is a matter of judgment based on the training and experience pursuant with the Attorney General guideline, domestic, other applicable law and policy and guidelines. The FBI employees must be useful, lawful method allowed, even intrusive whenever the intrusive is warranted by threat of the national security or potential victims of crimes and strength of the information indicating its existence. And that was all the way up to part 5, which this book was so far has been unclassified and for official use only. You can get it from the CPO, Chief Policy Officer, on the internet. This is a privileged document, cannot be released in whole and part of the person or agency outside of the Federal Bureau of Investigation, nor is it republished in whole or any part written not containing this statement, including general uses of pamphlets without approval of the Director of Federal Bureau of Investigations.